Hi, it's Mike DelSignore, Massachusetts OUI lawyer. Today's video, I want to talk about a recent case result I had in the Brockton District Court and wanted to talk about what led to the successful result in the case. It was an arrest by the Bridgewater Police Department. And sometimes when you get a case, there's some evidence you want to exclude. This was a case where the client refused the breathalyzer. I thought I had some good evidence in terms of I thought I could get the officer to acknowledge my client did well in the field sobriety tests. There was some bad driving, potentially a 911 caller that could be called to testify and did testify, and some alcohol in the car. So the alcohol in the car was something that I wanted to deal with, try to get excluded from evidence. So I did. I filed what's called a motion to suppress, saying that the search of the car wasn't permissible as an invalid inventory search. I was able to get the alcohol excluded, so that wasn't considered. The case did take a little longer. So the situation where my client obviously wanted to get back on the road as quickly as possible, but when speaking to the client, I said, you know what, we only get to do this once. Let's do everything we can to weaken the government's case. Whenever I file a motion to suppress an inventory search, alcohol in the car, and a breathalyzer, or any evidence I want to get excluded, usually I add the stop exit order in. And a lot of times I know I'm not going to get the stop suppressed. If you do, you win the case. But at least I get the officer testifying on the stop, the exit order. It's pretty much preview of the entire trial. So we did that, and we're able to get a key piece of evidence excluded. Then at trial, I was able to stress the fact that the client did well in the field test, the fact that a lot of the signs of someone impaired weren't present. Like when an officer's trained at the police academy that taught somebody under the influence might fumble, bobble for their license, have issues with dexterity, lean on the car, use it for balance. Those signs weren't present, so I was able to argue that these signs are inconsistent with impairment. And then I was able to stress that the standard of proof at trial is much different from the standard on the side of the road. Officer only needs probable cause to arrest. Here, proof beyond a reasonable doubt argued that it wasn't enough evidence. I did have to deal with the civilian witness. I had a civilian witness testify. And key part about civilian witnesses, you got to be careful because there's no police report. They can pretty much say whatever they want. The judge is probably going to believe them because generally people don't come to court unless it's necessary, and most of the time they're going to be very credible. So based on the direct examination, there was some testimony about bad driving, but I didn't ask any questions because I knew it could have been worse. There was a 911 call where the same caller described the driving in more detailed terms that would have been harmful to the case. So I basically thought I was ahead. And I told the client in our trial prep that we don't need to win every point to win the case. They score some points in these cases. And I thought, yeah, that's the best it's gonna be. Because sometimes you have a civilian witness on the stand. You might ask them a question. They may use as an opportunity to say what they want to say about the case. So you gotta be careful with civilian witnesses. You don't want to give them an opportunity to throw facts in that are going to hurt the case, because obviously they're against us. They know our client's charged with OUI, so you have to be careful with them. And often I ask very pointed questions, sometimes no questions. Had I asked questions, I was going to ask very specific questions. I actually sometimes speak to the witnesses prior to trial, so I know what they're going to say. Usually they stick with that. But it was going to be very direct questions where there wasn't going to be any room to elaborate. So that's what you want to do as a lawyer handling OUI cases or any criminal case. You want to make sure the witness doesn't have an opportunity to elaborate. It's cross-examination is our chance to show what our theory is, to teach the judge or the jury what our arguments are. And that's what led to the not guilty verdict in this case. The fact that the driving was minimized, the other observations weren't consistent with somebody impaired. So if you have a case in Brockton District Court or any district court, I practice all over Massachusetts. I've had a lot of cases with Bridgewater, East Bridgewater, Whitman, State Police. I know these departments well. I'm very familiar with that court. Be happy to help you. Call, text anytime, 781-686-5924. My name is Mike DelSignore. My passion is helping people make the best decisions for themselves when charged with an OUI offense.